Je veux remercier à l'Université de Laval et aussi Charles Emmanuel en particulier pour m'inviter ici de parler aux conférences. Maintenant, je dois échanger en anglais parce que autrement, j'ai peur le résultat et le titre au journaux et l'avocat d'Ontario a dit le commerce est plus important que l'environnement. Donc, en anglais. And I always give the disclaimer when I do speak that I'm speaking in my personal capacity and I'm not representing the views of the government of Ontario. I think you've probably heard that from government speakers before. But I also would like to say as well that having worked for 6 years at the Federal Trade Law Bureau, roughly, and another roughly 6 now with the Ministry of the Attorney General in Economic Development and Trade, I have seen a lot of policy come my way, and that's what we usually do is assess whether policy conforms with trade and investment obligations. So the topic that I will speak about today, and I do apologize because I think in the program it says green subsidies. Given the time limit, the 20-minute time limit, I'm going to focus more on the treatment of green products and policy and the ability to justify environmental policy. I hope nobody came here specifically just to hear me speak about green energy. If you did, Charles Emmanuel may offer you a refund. If not, I'm happy to talk to you later at the cocktail party, and I'm happy to talk about green subsidies. Is it just a button? On the right. On the right, yes. Aha. Technology. Okay. So
it's a green one.
Yeah, ironic. So I'm going to first give you a little bit in terms of what we're talking about when we talk about green policy, an overview of that, the type of goods we're looking at. Then I'll next address trading goods and justifying green policy in environmental measures. In particular, I'll look at GATT Article 20. I mentioned the TBT too, but Professor Ouellette is going to speak about the interaction between the TBT agreement and the GATT, and I also think part of the chapeau factors into the TBT 2.1 analysis, and as well, the provisional justification is taken into consideration in 2.2 justification. So I think what I say will translate into the TBT as well, but I think it's instructive to look back at the jurisprudence, and then I'm going to offer a bit of a potential path forward, at least considerations for you to think about if people, I'm not taking a position whether there's a liberal enough review for environmental policy. I'm just going to point out considerations. If you think the WTO decisions are too strict when it comes to justifying environmental policy, perhaps a process or a way that we could get around that, and I leave it to others to make that determination. I am of the view, as I'll say, that I actually think the appellate body has done quite a good job overall in its assessment of environmental measures, and I'll explain why as we move forward. So, in terms of an overview, I mean, this is probably not new to anyone, but in terms of government policy and green initiatives, it's funny, I think back to the 80s when what the big issue was, I think, acid rain across the border coming from the United States to Canada, and then there's hazardous waste. But now, obviously, we're looking at climate change, we're looking at cap and trade systems, potentially carbon taxes, and even Ontario right now is part of the Western Climate Initiative. My government is looking now to how to go about with the cap and trade system, see how that would maybe connect with what obviously Quebec's doing and what California's doing. So there's also a European cap and trade system. So it's really relevant, the intersection here between trade and environmental rules. There's renewable energy, and you probably know Ontario's renewable energy program was challenged. I'm not talking about that much today. It's not because we lost. It's simply because the actual issues are more isolated. I want to stick to more systemic issues in my presentation. Then, of course, there are green products and services and eco-labeling that usually would fall to the TBT agreement, certification, and ISO standards, green production methods, and machinery. So it's the whole world of trade and goods. And also should mention, of course, right now in the plurilateral negotiations, there's an environmental agreement accord being negotiated, and there is some obviously progress on that as well. So one last thing before we dive a little bit more into the jurisprudence is just, this is not new in the sense that the environment has always been important at the WTO. It's sometimes, you hear anti-environment in the past, but I don't really think that's fair. I think there are mechanisms there, but you have to keep in mind it's still a multilateral trading system, and there are rights and obligations of both members, so you have to respect trade obligations, and there's that balance, as I'll get into, in terms of when you can justify environmental measures. One thing to consider, though, it's been around for a while, trade environment committees, and I look back and I was shocked to see that the acronym for an environment committee was EMIT. In 1971, but maybe that's why it didn't accomplish all that much, but it did help in leading to the Rio Declaration. Since then, we've moved forward a bit, and obviously in the preamble to the Marrakesh Agreement, you have references to sustainable development, to protect and preserve the environment, and factoring in the needs of different economies, meaning obviously developed versus developing economies. Then, also at that time, there was the Ministerial Declaration on the Trade and Environment, which formed the Committee on the Trade and Environment, and then more recently, well, 2001, but to some degree, was the Doha Declaration. And the important thing to consider in all these things, they talked about two things. One is the relationship between multilateral environment agreements and the multilateral trading system, and their dispute settlement mechanisms under these MEAs. So whenever I say MEA, that's Multilateral Environment Agreement for this presentation. And that's been an ongoing conversation for quite some time. The problem is not much has been resolved, and outside of the EGA context, I think what I want to talk about is maybe some path forward to potentially get some more movement if people do feel there's more of a need for a liberal review of environmental policy. So going back to the history, sort of past, then we'll get to the present and future. History of the GATT and WTO disputes when it comes to the environment. Under the GATT, there were both adopted and unadopted panel reports. There were 6 under the GATT system in total. All of them, in all cases, the environmental measures were not justified. You weren't able, the parties, the complainant proved a successful GATT violation, and the responding party was not able to justify it on the basis of environmental measures, and you probably know tuna dolphin as the most famous of that, because that has been in many incarnations throughout the dispute settlement system. Then we moved to the WTO DSU, and since 1995, it's been a little better, but overall still the majority of decisions have rejected a GATT Article 20 violation. So you see rejected U.S. gasoline, the first round of U.S. shrimp and Brazil tires. It was accepted in EC asbestos, and also the 21.5 compliance arbitration of U.S. shrimp. And I will focus more so on shrimp shortly, because I think that still is the most instructive decision. So I say here the score to date, trade 9, environment 2. I know it's a very much so probably Canadian humor, but it is like, to me, Montreal Canadiens 9, Toronto Maple Leafs 2. And I feel like, yeah, so I'm just totally playing to my crowd and switch it around depending on my audience. But so what can we conclude from these stats? I honestly think quantitatively that's it. They're numbers. Qualitatively, you can't conclude all that much, because I just want to make a couple points. First of all, and I think a lot of people here who work in government will know, you usually don't bring frivolous WTO claims. So even when there's a claim brought against you, in many cases, there's a fairly strong case to begin with, because you have to justify bringing the case. And even if there's an environmental aspect, often in a democracy, there are stakeholder interests, and those can sometimes push the policy in different ways. And that's something you just have to consider. From my experience, both at the federal level and the provincial level, one department that is, I would call it very principled, and I think you study it, and there is people who work for the Ministry Department of Environment. And I think that's why it rankles, in particular, I remember in the shrimp case, the U.S. Environmental Protection Agency, because they really truly, this wasn't stakeholder driven from what I could tell. It was more so, we truly believe we're doing the right thing. But in saying that, as I'll get to, I don't think it actually the appellate body. I think they gave them a path to do in their what would be a more reasonable accommodation when you're in the WTO system. The other part, which I'll get to now, is what's the mandate? And what I want to focus on is interpretation, because I think when we talk about environmental justification, we're expecting the appellate body and panels to do something that maybe we haven't equipped them with to do. In fact, I think they've been quite faithful to to the guidance of what they're supposed to follow. This isn't, of course, all their mandate. There are obviously other DSU rules, but under 3.2, their job, as we've heard from various speakers today, is to clarify the existing provisions of the covered agreements in accordance with customary international law, which is generally thought of to apply the Vienna Convention and the law of treaties, and also not to add to and diminish rights. So that's the balance that's really important to keep in mind. So when people just say, it's not an environment agreement. Environment is important, policy space is important, but the tools the appellate body has, what they have to do is apply the Vienna Convention to come to one interpretation, and that interpretation should not add to or diminish obligations of members, and that means both sides. And I think an instructive quote from the appellate body, oh, I think I went too far. That was my high tech. Okay, sorry about that. But I think turtle, come back. There we go. Okay. Took me longer to do that than the presentation, but but I think we're going back to the beginning, going back to U.S. shrimp, and of course, that case was about catching turtles, catching shrimp, but catching sea turtles in the net. And the United States put pretty strict measures that under Section 601, and I can't remember the specific legislation, but in that case, what I think is important to recognize is the appellate body talked about, and I want to show a quote in a second, the need to balance WTO members' rights and obligations. That's the first thing. The second thing is they talked about the proper role of treaty interpretation, which I just mentioned. So again, going back to their mandate under the DSU. And this was their quote that, I'm sure most of you have read, but I think it's always instructive because to me this is a signature passage of the appellate body. And they're clearly telling you the task of interpreting applying the chapeau, and it's the chapeau, but is essentially the delicate one of allocating and making out a line of equilibrium between the right of a member to invoke an exception under Article 20 and the rights of the other members under various substantive provisions, so that neither of the competing rights will cancel the others out. So I think you always have to keep that balance in mind, because otherwise the appellate body wouldn't be doing their job. And when we come to interpretation a little bit later, I'll make a few suggestions, maybe that we could think of in terms of giving the appellate body more tools to interpret more liberally if that's what the general consensus of the membership is. So I'm just going to outline the test quickly. I know there's a varied audience. I think students are here too, so hopefully most people know these. But there are two steps. There's provisional justification under Article 20, and then if you're successful to provisionally justify under an exception, you have to justify under the chapeau. With respect to environmental measures, there's obviously Article 20B and Article 20G. But the thing is, even though environmental measures have been either justified or attempted to be justified under these exceptions, they don't actually say the environment. It's been a liberal interpretation. Of course, they seem to fit. So later on we'll consider, do we need another exception? Do we need something that's more pointed just on the environment itself? And the TBT agreement, as a more modern agreement, as you see in many free trade agreements, in Ontario we concluded the seed negotiations a little while ago, and we've done other negotiations, and you start seeing more modern language that actually refers to the environment more, and you see environmental agreements obviously no longer like the NAFTA as a side agreement, but moving into the actual core of the free trade agreements. So under Article 20B, in terms of the test has been, it was originally stated in asbestos, then it was in Korea beef, and in Brazil tires, I think, was the clearest enunciation of the test. But I think what's important to remember is the appellate body, what they've said is they've had to interpret the word necessary to protect human, animal, or plant life or health. And what has that meant? They've developed a weighing and balancing test. And under this test, there are really three parts. The measure has to contribute to the objective, and it's the necessariness of the contribution to the measure, not whether the objective is necessary. Then this is an important thing in terms of thinking about interpretation going forward. It must be, the trade restrictiveness of the measure must be assessed in light of the vital or important interest. So in Brazil tires, in asbestos, the measure was found to be provisionally justified in both cases. They said, the appellate body said it was a vital interest. So the question is what's the environment? Is it a vital interest? Is it an important interest? And I'm not saying that I'm putting myself in the seat of the appellate body having to determine what's a vital interest. Does it mean there's immediate human harm, imminent harm? And because why that's important is because it speaks to how strict your measure can be. For instance, if there is a vital interest and there is imminent, let's say, human or animal or plant harm, well, maybe an import ban is more justifiable. But if it's something that can't be quantified quickly, it may take more time. Perhaps it has to be something less than an import ban, a tax, certification, permit, something else. So that's another thing. That's why I'm highlighting all these elements of going forward, the type of interpretation guidance we want to maybe provide to the appellate body or panels. Under Article 20G, apologies for a second as I always catch a cold before a presentation. I still blame my girlfriend's nephew. Every time I go near that baby, I get something. So Article 20G, that's the other exception where you can justify something under environmental justification. It says the words are related to conservation of exhaustible natural resources. 2 important points, exhaustible natural resources. That's important because the appellate body gave, and that was from gasoline, a pretty broad interpretation of what exhaustible natural resources are. They said the right to clean air. That's pretty broad. So again, the appellate body that is not a restrictive interpretation to put something under that as an environmental defense. It's actually quite broad. Then what does the word related to mean? They've said must primarily relate to the conservation of exhaustible natural resources. And I don't remember the precise language, but I think it's something like a genuine and real connection. So you have Article 20B, which is necessary. You have Article 20G, which is primarily related to. Again, in terms of interpretation, do we want to rethink this and maybe move something more towards related to rather than necessary in terms of making a more relaxed test? So under the chapeau, I think we're all familiar with this, but of course, even if you successfully justify something, it has to be provisionally, then it has to be justified under the chapeau. It can't constitute arbitrary or unjustifiable discrimination. And this is very relevant for issues like cap and trade, where you're looking at potentially measures where even though you're applying them domestically, they might apply effectively extraterritorially, I think, because often what's going to happen is you're saying, what's the measures that you have in place? We want to prevent carbon leakage, and what's happening in your jurisdiction, and therefore, what will we do in our jurisdiction if you don't have similar measures in place? And that impacts both trade rules, subsidy rules. But I think going back to the U.S. shrimp case, that case was interesting because actually, I have 5 minutes, so I'm going to actually move forward because what I really want to do, just to be safe, I want to get to more of the proposal at the end. I think that's a little bit more important. I just want to make one other point on the Vienna Convention rules and relevant rules of international under 31(3)(c). And I think that's important too. In the EC biotech, that was an issue, whether the EU could rely on, or in the context of the SPS agreement, the biosafety protocol. And that panel said, no, it's about, it's not about the biosafety protocol, it's about whether all the WTO members are party to that treaty. The appellate body modified that reasoning, or at least didn't accept it is maybe a better way to say. What they said in EC large civil aircraft was instead, what's important is the common intentions. So under 31(3)(c), if you want to bring in another treaty, how would you do that? You have to show it's the common intentions. That makes sense from a treaty interpretation standpoint. Obviously, you have the harmonized system, ILC articles, VCLT, that would qualify. But the question is, if it's a new environmental treaty, how could that ever represent the common intention of the parties who negotiated these agreements back in 95? So that, again, goes to where I want to go to in terms of future development. It was more cute the first time. Once you get down to 3 minutes, it's not as cute, the turtle, anymore. So the importance of environment, so I just wanted to go back and say the importance, so the appellate body has recognized through the jurisprudence the importance of environmental objectives. You read any of the cases, they refer to the preamble, everything else. They've talked about multilateral solutions, and that's even in the shrimp turtle, in the U.S. shrimp case. They actually said if this was negotiated on a multilateral basis, it may have been fine. In fact, that was confirmed, and the measure was found to be in compliance in the 21-5 decision. They've talked about not imposing a rigid uniform system on everyone. That was a problem with the U.S. measure in shrimp, but instead taking into account developing country realities. So this goes back to, I'll argue, the appellate body has been quite faithful to their mandate, and they've noted all these things they've told you, almost like, here's implicitly instruction if you want to give more space for environmental policy. The top bullets are things you should consider. They haven't said that, but that's the way I'm reading it. So these are the possible paths forward, and so I'll just take a few minutes and run through those. Some of these are obviously not new, but there's been suggestions of an amendment to Article 20, an amendment and an interpretation note in it. And actually, I should clarify, 2 and 3 are mine. Now, interpretation note, I bet you if I look through articles, somebody else, it's not original, but I will claim it for now. And an amendment, what past proposals have looked at is adding a new exception to get Article 20, and something like pursuant to multilateral agreements, you could therefore provisionally justify a measure on that basis, or necessary to protect the environment. I'm not sure alone that gets you out of the problem in terms of how do you interpret those. I think interpretive guidance may be a better way to go. Also, for anyone who has read the amendment process, that is not a light process, and there are many hoops to get through. So you could do amendment and interpretation note, but where I want to land more is that could work too with something like necessary to protect the environment. You could change necessary to relating to, because we know it has maybe a more relaxed standard to fit in more of a justification of environmental policy. And I just have 2 more that I'm done. The interpretation note to Article 20. This to me is not a bad idea. In the NAFTA, I know there's only 3 parties, but there's an interpretation note to Article 1105. In fact, it's been very instructive and helped clarify for tribunals how the parties want that to be interpreted. An interpretation note here is still difficult because it requires 3/4 of the membership. However, the benefit is it's not so rigid. It could be more flexible. It could be time limited. In that, we could deal with all the things that I was chatting about before. What's the scope of the environmental exception? We could talk about also, oh, sorry, I meant to go to the next slide, the weighing and balancing test. So we could say, for instance, remember when I said under GATT Article 20, there's vital interests and there's important interests, and the more vital the interest, the more space you may have to justify. So maybe we clarify with environmental measures. Environmental measures should be considered as vital, and maybe we have to provide that sort of guidance. And then with respect to multilateral environmental accords, how should those be factored in? And so when we get to the U.S. shrimp case, we can also look at something like that. So, and the last thing is developed and developing country considerations. We can avoid also, as long as it's based on a multilateral environment agreement, it's proportionate, it effectively implements that, and also you take into consideration the needs of developing countries, because realistically they don't have the same resources, both administratively and monetary, and that to me is something. We could do all this through an interpretive note. Yes, it wouldn't be easy, but it's easier than an amendment. The last point is just the good thing is the plurilateral agreement process is working for the Goods and Environment Agreement. That's been quite constructive so far, and I would offer potentially you could think of adding an interpretive note in there or having another plurilateral process. The thing with the plurilateral process, it seems because the membership is so large that this is sort of a helpful process still within the WTO structure. You couldn't access the DSU, but going back to the last point about common intention of the parties, what if people keep joining the plurilateral agreement? So the government procurement agreement is a good example of that. More and more you see the parties growing. You've gone from whatever it was to 13 to 15. Maybe it gets large enough that you get close to 3/4 of a membership, and then you have an interpretive note, and people who join the plurilateral agreement have to come in accepting that interpretive note. Just a bunch of considerations. Again, these are considerations, questions. You can shoot them all down. I'll be happy to debate them. And that's it. I'll leave it at that, and I hope you will invite me back for the subsidies portion I promised you, but I did not deliver on.